I am happy that my CryptoQ Media channel is back online. Following yesterday's announcement that the SEC would be appealing Judge Torres' ruling in the Ripple case, I provide in this video attorney John Deaton's analysis of the matter. John Deaton, who represented over 75,000 XRP holders globally, pushed himself into the case, organized court-approved visits to participate, and is thus an intriguing figure to me because of his central role in the XRP community's engagement with this matter. Plus, he has a lot of work piling up right now. Listen, I can tell you heard, but I'm not sure. He wasted no time sharing his thoughts on the case's circumstances, even though he is in the thick of his Senate race right now. So, I will paraphrase his claim, provide my thoughts on the matter, and then cite or otherwise mention a few of the specific examples he references. The fact that Bitcoin was once found to have been part of an illegal securities transaction, for instance, is not widely known. Were you even aware of that? That stuff is already up on my channel. In all honesty, I have no idea how common that is. I didn't know it until Deaton started bringing it up in recent years, whenever he first mentioned it. What happened shocked me. So, this doesn't meet the criteria for Bitcoin to be considered a security, correct? Please try it out. Now we can see where attorney Deaton writes his piece. According to him, a candidate for U.S. Senate would normally remain silent on the matter of challenging a district court ruling. I fought serious abuse of power and misconduct at the SEC in this particular case, using more than 75,000 of my personal funds and hundreds of hours of pro bono work to represent 75,000 token holders. The thing is, I'm not like other candidates. Okay, I'll take a moment to explain that I knew this was going to happen, despite the fact that it wasted his time and money. With the help of his own legal practice, he has been able to juggle several tasks. He has already brought up that statistic, perhaps I am just forgetting or ignoring it. But I just learned about that lately. You have to admire John Deaton and the amount of fire in the belly, as they say, that you must have to do something like that. 75,000 to pay for the privilege of fighting the SEC, if you want to call it that, and spending hundreds of your own dollars and hours that costs 75,000, because that emotion can't be fleeting if you have to have that persistent feeling throughout. To the fact that he went to such great lengths to do this is astounding, and he has had a significant impact on the result of the lawsuit by introducing sworn testimonials from XRP holders who were previously unrecognized. Consequently, it's rather impressive. The price of that item made me go, whoa, 75K for that, after reading this. I am personally persuaded. I'm aware that there is an appeal that is distinct from this one, but ultimately, it will have no impact on XRP holders. I'm just saying it because it touches close to home, particularly when you think about the seriousness of his crimes and the result of the case. After that, he continues. His only request was that the SEC rule that XRP was not a security in and of itself. Judge Castell had previously decided via telegram that the Gram token, which was like Bitcoin, was just a bunch of letters and not a security, so the request wasn't particularly ambitious. Sure, I'll have to take a moment to answer that as well. The SEC's claims on XRP's lack of inherent value were unfounded, and now we know it's just code. Will they even bother to appeal this decision? They contended that. Alright, I'll paraphrase a little, but that pretty much covers it. But what do they say as the case progresses? So, are you suggesting that asking them directly adds another level of protection? Their hypocrisy was on full show as they repeatedly contradicted themselves. Because of this, they found themselves in the regrettable position of still denying the necessity of supplementary security measures long after the decision had been taken. They could have prevented the 75,000 XRP holders associated with John Deaton, who had a major impact on the result, if they had been more honest from the beginning. If that were true, they wouldn't have lied and then used the same justifications, which I'll explain. They wouldn't be able to find you. They decided to be intellectually dishonest and try to ruin everything because of it. Seems absolutely absurd now that we have the benefit of hindsight. He didn't fare well in the end. Whatever the case may be, Deaton persists. In addition to that ruling, 75 years of precedent established without a reasonable doubt that anything may be presented, advertised, and sold under the guise of a security. What was never a security was the asset or object itself. Among other things, this encompasses chinchillas, citrus groves, Bitcoin, and condos. There was no conversion of Bitcoin or condominiums into a security. the investment contract in beavers does not transform into unregistered securities, it remains beavers. Anyone can purchase beavers. It is absolutely correct, given that it wouldn't alter the fact that XRP or Bitcoin are cryptocurrencies, even if someone offered them as securities illegally. After all, I have already discussed the film's exterior. I doubt that many people know this. In case you missed my previous video, I did say that Bitcoin was sold and packaged as a security. I thought this would be a nice opportunity to elaborate. It means a lot to me that you watched my video. Click the subscribe button and then tell me what you think when you're done.